Good morning. Thank you for making it in safely and soundly and being able to get here. So I assume that we're still going to take the cases out of order, and we'll be doing Carr first. Is that what everyone's still in agreement with regard? Okay, so I'm going to call the docket, and I'm going to call it in the order as it presents itself on the docket, not in the order that it will be heard. So the first case that is presented on the docket is In Re C Children, case number C220532. I understand that we're still awaiting one of the attorneys. Yes.
That's me, Your Honor, Jeffrey Fisher for the appellant, Corinda Childress. I made it earlier today.
Okay, all righty. And are you the only one present? Okay, all right, everyone's present, all right. And then we have two cases that have submitted on debrief, State of Ohio versus Dickey, which is case number C220536, and State of Ohio versus Taylor, case number C220226. And then we have Carr versus Educational Theater Association, case number C220240. Are parties here? Okay, and ready to proceed? All right, so we're going to start with Carr. You can come up to the podium when you're ready.
May it please the court, George Rule on behalf of the plaintiff appellant, Diane Carr. I'd like to reserve 2 minutes of my time for rebuttal. The issue for review is whether the trial court erred in granting defendant Appellee's motion for summary judgment. The standard of review on this appeal is de novo. It's our position that the July 5th email at issue in this case is defamation per se because it injured Dr. Carr in her trade or profession, educational theater. I have two primary arguments that I'd like to make. In the first district, the case law with respect to defamation has made clear that this court follows the totality of circumstances must follow the totality of circumstances by reading the entire email to determine whether a reasonable reader would interpret it as defamatory.
And let me ask you about that, because as I was reading your brief and you're describing this email, I kept wondering, okay, let me see the email, and it's not in your brief. You don't give us, I mean, we're talking about one email. There's not a series of statements. There's one email, and you don't even quote it in your brief. I had to go to the appellee's brief before I found out what was in the email.
Right. Well, we actually, I think in the reply brief, have the full email. Originally,
If we need to understand context, then we need to see the entire document, particularly when it's a short document like that. And as I read through that email, I understand your point about kind of the innuendo that may be in there, but I also see like, hey, we're going to undertake an investigation. We need to look at these allegations, kind of things like that. So how does that rise to the level of being defamatory per se?
Your Honor, I believe it's the clear message of the email. Now, Dr. Carr, she's a professional, and there's a body of case law in Ohio. She's akin to, I mean, she has a doctor of education. So the email defames her. The whole point of the email and the defamatory message is that Dr. Carr, by speaking at this Zoom event, is somehow a danger to students. And it's hard to imagine for an
But let me stop you there, because the email doesn't say that. If it did, that would be a clear kind of example of defamation per se. So if it doesn't say that, how do you get it to defamation per se?
Well, Your Honor, I think it's because that's the clear message of the email. And it's similar to the Scott versus Herald News case, the 1986 Ohio Supreme Court case. And in that particular case, the crux of the plaintiff's argument was, I'm being accused of perjury. The news article, which was, or the relevant portion of the news article, which was 9 sentences, never actually says Scott committed perjury. Yet it uses the word lie repeatedly throughout that article. And the court held it's very clear that the clear message, even though it's not stated, is that he committed perjury. Similarly, this email, it's 9 paragraphs. A couple of them are a sentence long, and throughout the email, it references well-being of students and student safety. And our position is there is no innocent interpretation of this email. So the
And I
defendant.
think you've got 2 challenges here. One is that it doesn't say something specifically defamatory in terms of accusing her of something. You're having to get there by implication. And then second, it doesn't identify her name. So you've got 2 missing links here to get to recovery. And I realize you cited some cases on the implication and some cases on not naming the person, but do you have any that have kind of connected both dots?
I don't know that I have a particular case that connects both dots. Just to address the not naming piece of it, it is crystal clear who this email is referring to. So the reference to some of the past,
To whom would it be crystal clear?
the recipients of the email. And Your Honor,
And is that the view that we would be undertaking, the recipients of the email, or would it be a reasonable person?
well, anyone who read the email would be able to ascertain who it's referring to, whether they were part of the organization or not, because it makes a very specific reference to who it's referring to. If it had generically referred to the 1984 NBA All-Star team, someone would be able to figure out who that is a reference to.
But doesn't that get to the issue of inference? So the recipients of the email, aren't they using knowledge that is in their purview in order to ascertain who it is about? Which is different than knowledge, this is knowledge that is specifically to them, and they would be able to infer. And at the end of the day, doesn't it come down to 2 people?
Right. Well, 3.
Well, only 2 of them were going to be speaking at this,
Correct.
right? So it really comes down to 2.
Correct. Right. It's defamatory to Dr. Carr because the recipients of the email are the ones that receive the defamatory message. It was blasted to the entire organization, not just the chapters who were holding the event. So there's no dispute who the email was referring to.
What I'm getting to is this, and you argue this in your brief, and then you're arguing it today, that it's defamation per se. And so, it's either not defamation, which is what the trial court determined. I'm not sure what she meant by it. Or it's defamation per se, or it's defamation pro quad.
Right. And it's not defamation per quad, because inside the four corners of the email, there is a clear defamatory message. You don't have to go outside the message.
So what do we do with the fact that the recipients are using their own specialized knowledge and by inference, getting it down to 2 people?
I still don't think the case law takes it outside the defamation per se, when it is, the recipients know who is being referred to. I mean, it gives a very, other than using her name, you couldn't get more specific in terms of who is being referenced. Some of the past ITO adult liaisons from 2013 to 2019. That's 3 people.
So, but how do we know it's her and not one of the other 2 people?
Well, it's all 3 of them. It's a reference to all 3 of them.
So you're saying it would be defamatory as to all 3 of them?
Correct.
And then let me ask you, like, I'm in response to your question, the question from Judge Sias, you're saying it's not defamation per quad. Is defamation by implication different than defamation per quad? And I'm trying to understand kind of exactly what your theory is in terms of which kind of bucket of defamation you would put this in.
Well, I misspoke when I said it's not, I mean, it would be defamation per quad as well, but it fits into the defamation per se bucket. Again, it is what my understanding of the law and the test is whether the particular language of the email provides a clear message, which, you know, we think is obvious from the email.
Mr. Rule, let me ask you if, concerning, of course, the defamation. We've read the email. Does the statement, "It is our duty to conduct a full investigation on all sides of these allegations, and we will need time to follow through and come to an appropriate resolution"? It sounds like this organization is going to talk to everybody and then have a resolution. Does that dissipate any defamation?
No, because the impact of the email is still the same. That's not the only thing that's communicated. That is part of the message, that, you know, we want you to postpone the meeting so we can investigate, but it also gives the who, what, and why. If you read it in context, the very first sentence, you know, the well-being of our students is our highest priority. And it is with this in mind that we are compelled to communicate with urgency. And then in the second paragraph, it gives the who, the past ITO adult liaisons. And then it goes into the what. We urge you to postpone this event. And the next 2 paragraphs is the why, because of these allegations. And what is false, the false statements in this email are actually not in and of themselves defamatory. The two false statements being, one, that this was a secretive event. Not true. The second false statement, that these were new allegations. These were not new allegations. They had already been investigated. If the letter from Kim Staples' lawyer.
So what is if you had to draw our attention to 1 or 2 aspects of this email that were the most pernicious from your perspective, what would those be? Like, what specific language?
We have received new information in the past couple of weeks that gives additional insight and severity to the 2019 program review. That's a false statement. These are recycled allegations that have already been investigated.
But if that's false, they haven't received new information, how does that impact Dr. Carr? Because they're saying, we got new information, and you're saying they didn't get new information. But how is that defamatory to Dr. Carr?
Well, again, it's the clear message of the email and context. And I think a case that's really helpful, which is cited in the briefs, is the Mucci versus Dayton newspapers case. It's actually a common pleas decision that I think is well-reasoned. But in that particular case, the two false facts that Dr. Mucci had left the area and that he was no longer working at these two hospitals.
So you have about a minute left.
Thank you. Ultimately, in and of themselves, is not defamatory. Yet, when you read the entire article in context, what the court says is it delivers a clear defamatory message, which is, there's no reading of this email that has an innocent interpretation that is not damaging to Dr. Carr, because it is hammering on student safety. And and the other point is, it's not a student safety issue. There was no reason to cancel a Zoom talk where she was speaking for 30 minutes. It was done with malice. And the fact that it was blasted to every chapter in the entire country, if their point was, we just want you to cancel the conference, all they had to do was pick up the phone and call one of these chapter directors that was putting it on. Instead, they blast the email to everyone in the country. And it was precisely because the organization wanted to damage, in particular, the board president, Scott Wilson, who was one of the other ITOs. At the same time, Dr. Carr, her reputation is trashed by them sending this email. Thank you.
Thank you.
Good morning, Your Honors. My name is Ryan Martin, and I represent the Appellees Educational Theater Association and Julie Theobald. This is a defamation case built entirely on an email that is not defamatory as a matter of law, as Judge Shanahan correctly ruled at the trial court level. The contents of the email never mention Dr. Carr, and critically do not state that she or anyone else did anything wrong. The email merely asked to postpone an event so that EDTA could fully investigate new complaints that it had received.
So what do we do with the statement that says, we have concerns about the event and we cannot assure the participants and parents that student safety will be protected, that will be communicated?
Right.
So doesn't that go a little bit more than postpone the event?
It does not, in my opinion, Your Honor, because the email specifically says just before, we have to investigate all sides of these allegations. They hadn't reached any conclusions, but until we investigate, we have to ask you urgently. This was on July 4th that they found these things out, and the event was the following day. And so they say, you have to postpone this event, and if you go forward with the event, then we're going to have to say our hands are off this event, is basically what they're indicating.
Well, they say, yeah, we can, it's going to say that it's not sanctioned, but it goes on to say that it's going to communicate that there were concerns and that they cannot assure the safety of participants and the parents.
That's right, but they do not say it is in fact an unsafe event. They do not say that anybody did anything wrong.
But I think that's where it gets to the implication and the innuendo. Like, yeah, they don't say it's an unsafe event, but, I mean, this is a Zoom presentation, and I hear you that there can be abuses over online medium. I understand that. But this is just like, a presentation. And the notion that these students are going to be potentially harmed which is the implication of the email if it goes forward, is difficult to square with like, oh, we're just investigating this.
Right, but there's a couple things to that. One, there were already investigations in the past that had occurred. In fact, this investigation that's the subject of this email, 2 outside investigators found that Dr. Carr did act inappropriately with these students.
Is that in our record?
Dr. Carr, in her amended complaint, states that she was found to have violated policy, that she appealed that decision, she lost that appeal, and that her membership in the organization was revoked. And as an individual whose membership in the organization is revoked, you can't participate in these events. So this isn't a situation, just when we talk about context, where an individual is falsely accused of something and it turns out we were wrong at the end of the day, and yet we send this email out. And at the end of the day, she lost her membership, along with the other 2 individuals who were accused in this case, and she can't participate in any of these events because of that fact. So at the end of the day, it's Dr. Carr is to blame for her reputation being what it is, to the extent that it has diminished in any respect because of her actions, which have led to these outside investigations finding that her
Is that argued
membership.
in your brief, that it's not a false statement? Because that's what I'm hearing you argue now.
Well, but we hadn't got to that point below because we hadn't had discovery, and so Judge Shanahan wouldn't have had the benefit to know whether it's a false statement or not. We're just talking about context, and we're talking about whether the statement is defamatory as a matter of law or not, which is what Judge Shanahan looked at. And what Judge Shanahan reviewed is the email saying, we need to investigate these allegations. They aren't saying she was guilty of this. They don't say what she did, as the panel rightly pointed out, versus another one of the adult liaisons versus the third adult liaison. They don't say who's charged with what. They don't make any specifics about what the allegations are. They simply say there are allegations, we have to investigate, and until we finish our investigation, we're urging you to postpone this event, which they did not know about until the day before, so that we can investigate the situation.
Well, again, I think it goes a little further than that. It says that if it doesn't get postponed, that they will communicate that there are concerns about the event and that they cannot ensure the participants and parents that student safety will be protected.
That's correct. It doesn't say that it's going to be an unsafe event, and it doesn't say that
Well, what would be the innocent interpretation of that last statement?
that our hands are off this event, and we can't say that people are going to be safe because there are allegations against the adult liaisons of abuse, of emotional abuse, and we can't tell you that this is going to. We can't tell participants that this is going to be a safe event if you don't postpone it until we complete our investigation. It is not saying that it's in fact an unsafe event, or that the event has to be canceled because she is unsafe.
Well,
to
let's
anyone.
assume that it is, let's assume that there is a false statement. Let's assume that it does injure Dr. Carr's reputation. What is your position as to whether it is defamation per se or defamation per quod?
It cannot be defamation per se as a matter of law, and I think that including First District Court of Appeals case law is crystal clear on this. So the law is clear that an individual can't proceed with a defamation per se claim, which Ms. Carr is attempting to do here based on implied defamation. That's the Martin v. Wegman case, First District.
What does that mean,
Court of Appeals.
implied defamation, and how would it apply to this case?
So I think if the email said Dr. Carr is unsafe, she abuses her students who are underneath her, and you have to cancel the event, that would be defamation per se, theoretically. This is not that. This case is we have allegations, we need to investigate those allegations, and until that investigation is complete, we can't sanction this event.
Doesn't that go right back to whether there's an innocent interpretation or not?
No, it goes to whether you have to make an implication to find that it's defamatory with respect to the plaintiff. And here, you have to make multiple leaps, as the panel rightly pointed out in questioning of Mr. Rule, which is that the statement was about her, which you can't tell from the four corners of the statement, but two, that it says that she has done something, and it doesn't do that either. So you
Cohen's
have.
position is that because it would be understood by the recipients that makes it defamation per se. How would you respond to that?
I think that that's incorrect. I think that it has to be a reasonable person, and it has to be on the four corners of the document or of the statement, that anyone hearing the statement would know that it's defamatory per se. And so that's,
And let me ask you, like, the question I asked to Mr. Rule, like, I'm trying to understand, is their theory about implication, is that the same as defamation per quad, or is there something different? Like, is there a different category that I'm not aware of between, like, defamation per se and defamation per quad?
so I think the case law has jumbled this up a little bit, but I think when you get to innuendo, there are two different arguments, at least that we're making. So one is, if you have a defamation through innuendo, it has to be per quad or nothing. It cannot be defamation per se. So that's the first thing. The second is, as the cases that we've pointed out in our brief make clear, if you have an innuendo type situation, but there's an innocent interpretation or construction of the statement, then it's not defamation per se or per quad. It is not actionable. And as the cases that we've pointed out make clear, and that's where I think this fits in. You have innuendo, so it's not defamation per se, but there's also an innocent construction. I understand that we can stretch to say, okay, well, why did they take the extra step at the end to say that they're not going to sanction the event or say that they can protect safety if they just had to investigate? But that's a stretch, that's a leap. And one innocent way to interpret that, which is reasonable, is that we have to investigate, and until that investigation is finished, our hands are off this event. And we're going to tell everybody that our hands are off this event and that we can't protect these people because we
Looking at, in this innocent interpretation, you look at the totality of everything. So if it seems like you're pulling out one statement.
You look at right, but the plaintiffs, the appellants want to just look at the safety and the last line. But you have to read that
I
in
think they're
context.
trying to look at that last line in light of everything, or everything in light of that last line.
I think they're looking at the last line completely discounting anything about investigating. I mean, it's any reasonable person who reads that document would know that there's allegations made, that those allegations are being investigated, and that there's not been a conclusion to the investigation yet.
Wouldn't they know that those allegations have to do with safety?
Well, yeah, absolutely, and they would, but that doesn't mean she's done anything wrong. That means you have to investigate. It's just like in the employment setting, where you suspend somebody pending an investigation, and you don't know whether the allegations against them are true or not, and you got to tell their supervisor, you got to tell these people what's being alleged. That's not defamation. I mean, it might come out at the end of the day that the allegations made against that employee were completely false, and you bring them back, and maybe you give them back pay if you suspended them without pay, but they can't sue the employer for defamation because all they're saying is we have allegations, we're investigating those allegations, and until then, we haven't made a decision yet, but you got to be out of here because we think you might not be safe for some reason. And so it's just like that, where that's all that's being said here is that this organization has to investigate. These are serious allegations involving 16-year-old kids, and we need this event to be postponed until we can conclude the investigation. That's a completely reasonable, non-defamatory interpretation of that email. And under Ohio law, if there is that interpretation out there, then this is not actionable defamation.
Does the record, was this being billed as an, whatever the acronym is, the EDTA, sponsored event?
So
Does the record disclose that?
The record is that the chapters were putting that together. So there's chapters in all 50 states. And so there were about 5 or 6 chapters that were putting this together. And EDTA, through the email, I think, is really the only thing in the record. Says, well, we didn't know about this. There's an allegation that the chapters were putting the event together secretly. It's because they didn't know about it until the last minute. And so that's what that piece of it was, which is why there was urgency for them to get them to postpone the event that's happening the next day. But in the case law, I do think it's vital in these cases. There's not a single case that's like this that the appellant has cited. The appellant, Mr. Rule, just talked about the Scott versus News Herald case. In that case, there was a publication saying anyone that was in the room at this hearing, quote, knows in his heart that the 2 plaintiffs lied at the hearing. It's a direct statement. We don't have anything like that in this case. And you can go down the line of cases. All of these cases involve direct statements, and there could be innuendo. It might not be as clear as they lied. But the innuendo is that they've done something wrong. All of them. And this case has nothing like that. This case is there are allegations that need to be investigated, and until then, we can't sanction this event. We're not saying she did anything wrong in that email. We never say that. And there's no reasonable interpretation that says that we did indicate that she in fact did something wrong. We're just saying we have to investigate, and you have to stop the event until we can continue to investigate. In fact, this McGuire v. Roth case that was cited by the appellant, that's a case that was dismissed on a motion to dismiss, even before any discovery at all. And the allegation there were an indication that some are wondering if water board members received kickbacks because of who they hired to do a job. And the court in that case said it's not enough to be defamatory. No one was charged specifically with doing anything wrong, and the statement was that some individuals were wondering if there was something there. That case is even more egregious than this one in my mind, because all we're saying is there are allegations that we have to investigate, period. And that's all. We don't say that she in fact abused students. We don't say that she's a danger to these students. All we say is that there are allegations that have to be investigated, and until that investigation can occur, we really need you to postpone this event and for the conclusion of that. And so in that way, this is different. I can't find a single case, appellant hasn't cited a single case, where the individuals say we need to investigate allegations, and that is being found defamatory, even if the allegations are being proven false. So in that way, I think this case is like the ones that we've cited in our brief, the Krems case, the Osborne versus Knights of Columbus case, where individuals are, through innuendo, trying to show that they were defamed. So for example, in the Knights of Columbus case, the plaintiff resigned a position, and the individuals went to their customers and said, the plaintiff left the agency to pursue other interests, and that was combined with a statement that said that his leaving would lead to, quote, much higher level of service. And so the person sued and said, well, they're saying to my customers that they're going to get better service because I resigned. And the court said, well, yeah, it's arguably, quote unquote.
You have about a minute left.
Oh, thank you. Quote unquote, arguably, impliedly defames the plaintiff, but dismisses because Ohio does not recognize libel through implied statements when you have this innocent construction of the statement. So they said you could have interpreted that statement to mean, well, we can bring different people in, we can restructure, which will lead to better service for the customers. So the law is clear that if there is an innocent way to reasonably view a statement, that it cannot be actionable defamation. Judge Shanahan looked at that. She looked at the statement. She looked at the email that we've provided throughout this case, because we strenuously believe it's not defamatory, and she believed that we were right, that the email in question only said that an investigation needed to occur, did not say that Dr. Carr or any of the other two adult liaisons, neither of which has sued the organization for anything, was guilty of anything, and therefore it wasn't defamatory as a matter of law. I appreciate it. Thank you.
Thank you. You have your 2 minutes.
Thank you, Your Honor. In the Elwert versus Pilot Life Insurance case, which is a First District case from 1991, the court writes, a publication will be considered defamatory per se when it appears that the publication reflects upon the person's character by bringing him into ridicule, hatred, or contempt, or affects him injuriously in his trade or profession. This email does that. If the words in the publication are reasonably susceptible to an innocent construction and are not defamatory in themselves, they cannot constitute defamation per se. It's our position that there is no reasonable reading of this email that doesn't defame Dr. Carr. The clear message is that the meeting needs to be canceled because student safety is at risk. It's throughout the entire email. Defamation by implication or innuendo can be defamation per se when the message is clear. It doesn't have to be explicitly stated. This email harms Dr. Carr in her trade or profession.
I just want to make sure I understand that. You're saying defamation by implication or innuendo can be defamation per se? Because I thought they were mutually exclusive.
No, I think they can be defamation per se when it's an email that harms an individual in their trade or profession, and there is no reasonable, innocent reading of the email. And if the message was simply, we have new allegations and we need
Just
to.
for clarity, what you're saying is that a written statement in which there is no innocent interpretation is defamation per se.
There are other elements required, such as a
Or
false.
can be defamation per se.
Can be
if it meets
defamation
other-
per se.
yes. Okay.
But yes, and the cases that say, and this is the Gupta case, to question a doctor's professional skill is presumed to be defamation per se. Here, you're talking about a professional educator, and it is very clearly stating, you've got to urgently, the clear message is, you've got to urgently cancel this Zoom conference. Why? Why do you need to urgently cancel the Zoom conference? That's clearly communicated in that email. Just like the Scott case, it is safety,
I'll give you a
safety,
couple seconds to wrap up.
safety. Thank you. We would ask that the case be remanded to the trial court for further proceedings. Thank you.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission, issue a timely decision. Wish you a wonderful afternoon and a safe drive home.
Thank you.
Thank you. In Racy Children.
Your Honor, I'm technically the appellee, but I'm going to sit over here just.
Well, you could, you can move the chair, you can do whatever you wish. Is there any division of time?
Yes, there will be an equal division of time between HCJFS and the Guardian ad litem.
Okay, all right.
I would ask for 2 minutes or 1 minute just so I could give my opinion. I'm also,
Okay, so
I just need.
2 or 1? Because it becomes an odd number depending on your answer.
I'll ask for 2.
Okay, so if you're asking for 2, that gives you 13.
I'll take 6.
Okay,
Okay, that's fine.
all right. So 7, 6, and 2.
Whatever you have left.
Okay, you're easy, you're 15. You get to let me know if you want to reserve time.
I was thinking it, but I wasn't going to say it.
It doesn't give you an upper hand, okay?
Understood.
Would you like to reserve time?
I would like to reserve 3 minutes,
3
please,
minutes,
for
all right.
rebuttal.
Perfect. Whenever you're ready, you can start.
Thank you. May it please the court, opposing counsel? I'm Jeffrey Kutcher. I represent an appellant, prior legal custodian, and grandmother, Corinda Childress. We're here for a parental termination case, which also terminates the rights of my client as the prior legal custodian. This is a person who's been in loco parentis of these children with legal custody since 2014, and I think as a caregiver a little bit before that. So I view this as the termination of Corinda Childress's parental rights. We asked the court to consider this termination as Ms. Childress was not represented at the permanent custody hearing that terminated the biological parents' parental rights and basically made Ms. Childress not a family member anymore. I think we can all agree it's clear there's no express waiver of counsel. There was never a colloquy from the magistrate to Ms. Childress. There's no indication that she knowingly, intelligently, or voluntarily waived her rights.
And is it your position that there has to be some type of Miranda warnings related to the right to counsel before someone can essentially waive the right to counsel?
We do take that position. I didn't indicate that at all in my brief. However, we know that the Ohio Supreme Court has likened these cases to be the family law equivalent of the criminal death penalty. And so if we take that seriously, and obviously we should, the Supreme Court has spoken, then we think there should be some sort of Miranda-type warning that you're proceeding without counsel, you have the right to counsel, would you like counsel? And we'll acknowledge.
And so, like, what is a magistrate or juvenile court judge to do in a situation like this, or similar situation where the hearing's been delayed several times, and then, like, you get to the hearing, and she doesn't have counsel, everybody's ready to go. Do you just then keep postponing the hearing because she's not getting counsel?
Well, at the front end, let me respectfully say, if I remember correctly and understand correctly, this was the very first time that this case had been set for
I know, I was.
permanent custody.
Sorry, I was
Okay.
changing the facts on you, but
Okay.
yes.
Should you change the facts to those, there has to be some sort of warning at some point. I know the magistrate in this case says, you've had the opportunity to have counsel, you've fired counsel, and let me try to get the exact quote here. And you chose not to be represented. When the magistrate told my client that she chose not to be represented, my client immediately spoke back and said, that's not true. And so, back to your question, should we delay? Not too many times.
It wasn't that your client first articulated that it was her intent to hire private counsel?
I think the first time she articulated that is when she indicated that her second attorney, she didn't want the services of Mr. Lanzalotta anymore, who was her second attorney. And she indicated that she was going to hire counsel. She didn't hire counsel, but she did apparently go back to the public defender's office and request a third attorney because Ms. Weingartner-Klug appeared at some point after that to be her third counsel. We know that Ms. Klug then withdrew as well, and my client, again, for a second time now, indicated she's going to hire counsel. And
See, and I found that to be very interesting, because when you're looking at the totality, if she has articulated that she intends to hire counsel and then shows up without hired counsel, when that is what she articulated that she intends to do, what do we do with that, considering the totality of the circumstances?
ask the magistrate to have a colloquy with her. Ms. Childress, you told us that you were going to hire counsel. I don't see counsel with you. Have you in fact hired counsel? What happened? And
Well, let me stop you there, Mr. Kuchar. That my understanding that she showed up with, I believe it was somebody called her attorney, in fact, right? And then,
that's right.
right, so you show up, everybody's ready to go. You don't indicate that you wish to have counsel until such time as you begin cross-examining a witness. And then at some point, it dawned on your client that she had no conception of what she was supposed to do. Wouldn't it be, and at that point, I believe she asked, her attorney, in fact, said, I'll go find somebody. And at that point, the magistrate said, no, we're going to continue. So I'm getting to the question. The question is, isn't this more of us looking at it as an abuse of discretion on the part of the magistrate for failing to continue this matter in progress that's been pending for, 2 years? So that's the question. And it's noted, the prosecutor noted it in her conclusion.
Your Honor, I'm not sure that the magistrate exercised any discretion at all. My client showed up late to that permanent custody hearing, and she showed up 50-some minutes late. But if we delve into that transcript, the hearing started so late that I think she appears on the 4th page of testimony in a 126-page transcript.
I thought they waited for her, and she explained that she had car trouble.
Well,
Is that right or wrong? It sounds like they waited 50 minutes, and she said, oh, it's the car trouble, emergency room excuse.
I think that's just a little bit wrong, respectfully, Your
Okay.
Honor. I think what the transcript indicates they were waiting for were the parents, the biological mother and father. I think all the questioning from the magistrate was, where's mom and dad? I don't think the magistrate asks one time, where's this prior legal custodian, Ms. Childress? Now, when she shows up, 4 pages into testimony, she says, I called, I had car trouble, whatever it was, and I understand the typical excuses for being late. But she indicates she called. The magistrate says, well, we didn't get any information that you called. And here's this Mr. Williams character that she brought with her, her attorney in fact. Now, at some point, we get to the magistrate saying he's not an attorney, he's not allowed to practice law, so he's not allowed to ask questions. But apparently, he can write his questions on a piece of paper and hand them to you, and you can ask those same exact questions, and that's not practicing law. I think we get into confusion here. Whoever that man is, her attorney in fact, whatever that means in her context, he indicates that she doesn't understand. Ms. Childress doesn't understand. And I don't, if we take not understanding far enough, then maybe we have a person who doesn't understand to the extent that they might need a guardian ad litem appointed for them. And if we have that situation, then we've got the M Children case.
Well,
That's
I mean,
exactly-
it seemed to me that she clearly didn't understand the nature of the attorney in fact, power of attorney, whatever he was called, and assumed that that meant he could effectively function in an advisory capacity during the hearing. So I don't know how, I don't know which way that cuts, but clearly she didn't understand.
Right, she did not understand.
Right.
But the magistrate lets Mr. Williams speak some more, and he says, I have the money to bring an attorney next time. And he implicitly, I'll say, suggests to the court, hey, let's do whatever you want to do today, but when it gets to Ms. Childress's case in chief, let her come back next time with an attorney, which I think would have been a very reasonable continuance under the totality of those circumstances. Ms. Childress confirmed at that time that she doesn't have the money, but apparently Mr. Williams does. And when Ms. Childress entered the room, she saw a trial in progress. She would have had no idea that it just started 5 minutes ago versus it started an hour ago because she's an hour late. And so I think she respectfully responded to the magistrate, took her seat, and when it was her time to talk, at the time of cross-examination, at some point then she says, can I come back with my lawyer? And that's where the magistrate said, you chose not to be represented, you had opportunities, but to choosing to be not to be represented, Ms. Childress says, no, that's not true. And so I think we're asking the court, forcing the court respectfully for the first time, as I understand through that M Children case, the court has not, the first district has not yet decided whether there can be an implicit waiver, and if there can be, then what happens? Adopt a totality of the circumstances based on other districts. That's certainly what Judge Powers did in this case. Judge Powers took a totality of the circumstances view. But our position is, under the totality of these circumstances, Ms. Childress wanted counsel. She could not afford counsel. There was no colloquy with Ms. Childress to see what the status of that counsel might be. And to an abuse of discretion, I think that it was an abuse of discretion at the moment.
So what if the, when she fired her last attorney, and the magistrate just had an update conference and said, "Are you planning to hire a new counsel?" And she said, "Yes, I am." And if at that point the magistrate Mirandized her and said, "Well, if you don't hire new counsel, here's what's going to happen. You should hire new counsel, like it benefits you, blah, 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 whatever." So we fast forward a year now, and then she showed up at this hearing. Like, I'm trying to understand, like, are warnings a year out sufficient from your view of the world? Or do they have to be close in time to the actual proceeding? Like, I'm just trying to understand the contours of the rule from your perspective.
And counsel, you have about a minute left.
Thank you. Typical lawyerly response, it depends. Would warnings a year out be effective when permanent custody was not yet on the table? That motion had not been filed yet. I'd like to see the Miranda warnings after the filing of the state's motion to terminate temporary custody and ask for permanent custody. I think a warning after that time. Now, if that was a year ago, I think that's fair, if it's been continued for a year. But I think that's the time frame. And then I'd also like to address, as far as a Miranda-type warning goes, why would a magistrate, understanding that the Supreme Court has said this is the family law equivalent of the death penalty, why would a magistrate not have standby counsel? I think in a death penalty case, we would certainly have standby counsel. I can't even imagine a death penalty criminal case without counsel to begin with. But I think we've seen murder cases and other high-level felonies where you want to represent yourself, fine, here's standby counsel for you. And so I think that would go along with the warning. After being warned, after that permanent custody motion was filed, then have standby counsel. Why allow that last attorney to withdraw? I understand the attorney files something and alleges a breakdown of the attorney-client relationship, but it's so important. Are you sure you can't resolve your differences? And if you can't, that's fine. We're going to appoint somebody for you. If you don't want them, fine, but they're going to be there at least as standby counsel.
Thank you, counsel.
Thank you.
Attorney Browning?
Yes.
So you have 7 minutes, right?
Yes,
Okay.
thank you.
Thank you.
May it please the court, I am Michelle Browning, representing Appellee Hamilton County Job and Family Services today. As Mr. Kutcher discussed, the part of the case that we're here to discuss today is waiver of counsel, and if that can be implied in a case such as the C children. When considering the totality of the circumstances, which is referenced throughout each party's briefs, throughout the order of the juvenile court judge, and throughout the In Re M case, the totality of the circumstances with the C children amounts to Ms. Childress's continued disengagement from this case as it proceeded over a 2-year span at the juvenile court. First, we start with the lack of counsel at the permanent custody hearing. As Mr. Kutcher stated, and
Well, let me ask you this. The cases that I've read in this space, even on the inferred or implied waiver, do seem to suggest that it is incumbent upon the court to provide some admonition, some type of warning. I've been using Miranda for short. Is it your position that there is no obligation on the court to provide any sort of advance warning to a party who is proceeding without counsel in these circumstances?
I believe that it is important for the court to reinforce that parties have a right to counsel. And what I would say counter to Mr. Kutcher is Mr. Kutcher stated this motion had not been filed previous to Ms. Childress firing her prior attorney, and that the severity of the motion therefore should have prompted the court to ask at that time if Ms. Childress would like counsel. What I would say in response to that is this was the first hearing that the motion preceded. However, there were several pretrial settings, and there were several other hearings prior to this in which, if Ms. Childress had attended, that engagement, that Mirandizing, as you referenced it, could have occurred. However, Ms. Childress's attendance was sparse. It was irregular. So the court, prior to the hearing, did not have the opportunity to engage in that conversation with Ms. Childress. And on the day of the hearing, we've already discussed 15 minutes.
So I hear you that maybe she wasn't the most engaged, and that creates a quandary for the court. But the court's also seen and approved 3 attorneys withdrawing, and that should be red flag to court that there's an issue here. And it seems to me that if there is some obligation to the court to advise a parent in these circumstances or custodian in these circumstances, seems like the court needs to figure out a way to do that in advance, being mindful of needing to move the docket along in a responsible manner. And if she's not showing up, then you send her a notice and say, you need to have counsel. Here's the consequences. If you don't, here's your rights to a lawyer. I mean, I don't know what it says, but I mean, there's ways to get around that.
And to that point, I would counter that I can't speak to the specific language that Ms. Childress was provided. However, she was served with the motion, and she was aware of the court date. She was being sent notices. She was being mailed the prior entries. There's nothing to indicate that she had not received those notices or that she had not received service. To your point of specific language, again, the language of those notices does tend to state the next hearing, where it will be, how to access it. I don't know if language that is appropriate for meeting a Miranda-style notification could be included in that. However, I would just add that Ms. Childress, as you stated, she's hired 3 attorneys previously. I think that the statement that she was not understanding, I don't believe that that's accurate in this case. I think that the hiring of 3 prior attorneys and the firing of those 3 prior attorneys, whether the court should have allowed 3 firings, I think it shows a knowledge of the system.
Well, I tend to disagree with you on that, mainly because, and I can't remember if it was your brief or the GAL's, where you're suggesting that shows some sophistication on her part in terms of understanding the proceedings. And I look at the transcript where she's got this attorney, in fact, whatever he is, and clearly she thinks that means he can act in a representative capacity. She's just wrong about that. And to me, that shows a lack of familiarity or understanding with the proceedings.
And I will say, I understand that her expression of her bringing this person with her, her believing that they could perform as an attorney, I would say I don't imply that she has a level of sophistication, more that she is familiar with the process. And I do understand that her statements might show she had someone with her she believed could represent her. But contrary to that, I would argue that throughout these years that this was pending, she had successfully hired 3 prior counsels.
My understanding is that at the first point she requested counsel was on the first witness, the Job and Family Services witness. Is my correct, or how far did it go before she asked for counsel?
Counsel, you have about a minute left.
Thank you. That's my understanding as well, is that it was the first witness that Job and Family Services presented, and it was at the time she was offered to cross-examine this witness, that she stated she did not know how to proceed and requested to come back with an attorney. That is my understanding as well.
Thank you.
In conclusion, Job and Family Services is requesting that the appeal, or that the decision of the juvenile court be upheld. The totality of the circumstances reflects that Ms. Cook did, or Ms. Childress, I apologize, Ms. Childress did in fact waive her counsel by implication through her failure to arrive on time with counsel, her lack of participation in prior hearings over the last historic 2 years of the case, and through her ability to hire previous counsel. Thank you.
Thank you. Good morning.
May it please the court, my name is Victoria Link, and I am the attorney guardian ad litem for the C Children appellee on this case. I'm just going to jump right in from where JFS left off. It is my belief that Ms. Childress did maintain, as you expressed it, Your Honor, a certain level of sophistication in understanding not the legal proceedings, not how to cross-examine a witness or the skills that we would expect a lawyer to have versus a layperson. But it is my belief, as I expressed in my brief, that Ms. Childress did have a sophisticated knowledge of how the appointment process works for how to get counsel when you cannot afford an attorney, as she expressed in the transcript at the permanent custody
Did anyone ever
hearing.
tell her, kind of advise her what the consequences were of proceeding without counsel?
That I do not directly recall. I do know that it is the standard practice of the juvenile court magistrates to inform parents, and in this case legal custodian, of their right to an attorney. And the first two attorneys that she had were appointed directly by the court. So those appointments occurred before I was on this case, but based on my review of the trial docket, it is my belief that she was told of her right to an attorney, but whether that included the consequences of not having one, I do not know.
But let me, on the date of the trial, it's my understanding she was not advised of her right to have an attorney present to assist her. Am I correct in that?
That is correct. And I would also like to speak to the missed hearings that Ms. Childress missed, that the JFS brought up as well. It is true that other district courts have looked at missed hearings as part of the totality of the circumstances. And I don't think that the missed hearings really speak so much to that she didn't have a chance to be notified of her right to counsel, but her lack of engagement with the court process because of the importance of the hearings that she did miss. The hearings that she missed were the dispositional hearing and then an additional hearing on a motion to extend temporary custody. So the hearings that Ms. Childress failed to appear for previously were the hearings where temporary custody of the children was granted to the agency in the first place, and then the hearing where that temporary custody was extended. So she had failed to participate in previous hearings where she could have contested the right of the agency to get temporary custody, to the merits of the agency's case to gain temporary custody in the first place. Those are the hearings that she missed. She also appeared in between all of those hearings without counsel. She did not consistently maintain that she was going to get private counsel. It was a statement that she sometimes made. And so she also then, after firing her third attorney, remained unrepresented for nearly an entire calendar year. So while she maybe was not apprised of the consequences of moving forward without an attorney, she was familiar enough with it that she had moved forward without an attorney on her own and had continued to not regain custody of her grandchildren. So she was at least aware that that could happen without having an attorney through her actions.
So is it your position, I'll ask the same question I asked JFS, that there is no obligation on the magistrate to advise a parent or custodian in these circumstances of their right to counsel and the consequences of the failure to have counsel? Like, the Miranda type one.
Well, it is my belief that as the law currently stands in the First District, the obligation to advise on the consequences of not having an attorney does not exist. And as I stated, it is the custom of magistrates to advise on the right to an attorney, and I do believe that that is necessary and, like I said, to my knowledge, did occur in this case, but I don't believe the law.
In Re M, and I don't have that in front of me right now, but I thought that we noted and said that there needed to be some type of admonition.
Okay, well, I could be mistaken then, Your Honor, and I do apologize for that, but NRA M was also a very narrowly tailored case about the competency for a mother who had a GAL appointed. And Ms. Childress had 3 attorneys who never once brought to the attention of the court the possibility that she would need a GAL. The 3 attorneys that did represent her, that she did maintain an attorney-client relationship with, however tenuous that relationship was, did not have any questions of her competency. And so that goes back to my original point that just because she did not have the same competencies to practice law as an attorney would, does not mean that she is not competent to waive her right to counsel or to seek yet another attorney through the public defender's office, as she had done in the past. Also, as regarding her conduct at the private custody hearing, Ms. Childress did arrive at 9:50 for a 9 a.m. trial. She did miss the pretrial that occurred before that permanent custody trial, but she was served the entry from that pretrial that stated that the permanent custody hearing, would be at 9 a.m. and she arrived 50 minutes late for that. She'd received notice 3 months in advance, and so she also then had time to seek counsel from the public defender's office, to call that phone number, be appointed an attorney who could perhaps even appear in the capacity to say, Your Honor, I've been appointed on this case. My client would like to obtain private counsel, but she didn't and can't afford to right
I
now.
don't think anyone's arguing that she didn't have the opportunity to seek counsel. I think it's more of whether the case should have proceeded without counsel under the circumstances. You've raised a couple times how she would have been advised of her right to an attorney. Are you saying that infers that she should have known that the proceedings would have gone on at some point, or if she didn't get an attorney?
Yeah, I think that when she has been advised of the right to her attorney since the day one, and then she had appeared so many times without an attorney, that to an extent, yes, because every other proceeding in this court had gone on without her being present with an attorney. The disposition went on without her being present at all. The motion to extend temporary custody went on without her being present at all. So I don't think it's unreasonable for that to serve as notice that this hearing could go on without her having counsel. I don't think that's unreasonable.
And I'm going to give you a couple seconds to wrap up.
Okay, thank you for that. And I just wanted to state again that several districts in Ohio use a totality of the circumstances test to determine if a parent knowingly, intelligently, and voluntarily waived their right to counsel. And it is my belief that Ms. Childress did by firing several attorneys, failing to attend several critical trials throughout the proceedings of this case, and then arriving late without counsel to the permanent custody trial. Thank you.
Thank you. Last but not least, 2 minutes.
Very brief. May it please the court, my name's Roberta Barbanel, and I represent the mother. And I am in agreement with Mr. Kutcher's position. My client has had a change of heart and feels that her mother was entitled to counsel and wants her to remain the legal custodian and would like to see a remand. I do want to clarify a few things. I'm not sure Ms. Childress understood the whole court proceedings. She did fire 3 attorneys, and I would suggest that it was because she was frustrated with the proceedings, didn't understand necessarily what they were talking about, and she didn't get the results she wanted, so she fired the attorneys and wanted somebody that clearly would do better for her.
Would you say that in the totality of circumstances, did she waive or not waive her right to counsel?
In my opinion, I don't believe she ever waived her right to counsel. And I think it was clear, she showed up with this gentleman, she didn't know that he wouldn't be allowed to help her ask questions. And she showed up late. When she was questioned about it, she said, you know, I called the court and told them I was having trouble with my car and I had to get other transportation, I was going to be late. That didn't translate and ever get to the magistrate. She was told to sit down. They made arrangements for people to move over so she could sit down, and we just proceeded. And then, when it got to be her turn, that's when she started, and she realized this gentleman couldn't assist her. That's when...
Didn't she pronounce that he was her power of attorney?
She
Not
did.
her, like, attorney for the proceedings.
And
And didn't she also say that he was the person who was trying to help her get the funds to hire an attorney?
Correct. And he offered, while the proceedings were going on, to pay for her attorney.
So that's,
And
would you say that that was perhaps a pronouncement that she still
Wanted
intended? Yeah, exactly.
that she always intended to have counsel. And when she realized that he couldn't assist her with counsel, with the questions, she started trying to ask questions, and she clearly realized she was in over her head. And he offered to pay for counsel and asked if her case in chief could occur on a different date, which probably would have been the reasonable thing to do at that point, allow the rest of the trial so we didn't waste time to go forward, and then allow
Both you
it.
and Mr. Kutcher argue reasonableness, but is that really something for us to consider? Because isn't it, it's an issue of law or perhaps an issue of abuse of discretion? If it's abuse of discretion, it's whether it's capricious. If it's an issue of law, it's whether the law requires it. So how does reasonableness then factor into it?
Well, there was no implicit waiver of counsel. She made herself abundantly clear that she wanted to be represented for this proceeding. And as the case law indicates, this is likened to a criminal proceeding where it's like a death sentence. She's going to lose her children. And, you know, she wasn't represented when the motion to modify from temporary custody to permanent custody was sent out. That's confusing to people, to modify temporary custody to permanent custody. I don't think the normal person is going to understand what that means. So I don't know whether she understood that her parental rights were going to be terminated at this hearing, because I don't know that anybody ever fully explained the ramifications of this hearing to her. So, yes, would it be reasonable, in light of the fact that she had not gotten continuances and nobody had ever asked for a continuance on a permanent custody hearing, and they happen frequently in this court, that would have been reasonable to allow her to present her case in chief when she was able, especially because everybody knew she was going to have funds to go obtain counsel, give her another date to have a hearing where she could present her case rather than allow her to lose these children. But so in sum, I would ask that this case be remanded back for another trial where Ms. Childress could have counsel representing her. Thank you.
Okay, not quite last but not least. Okay, so you have 3 minutes, right?
Yes, please.
Okay.
Thank you. So obviously, I want to get my big point out before I run out of time. And Ms. Barbanel stole my thunder a little bit, but Ms. Childress...
She made your job easier.
She did. Ms. Childress always indicated that she intended to be represented. Now, she talked about hiring counsel. Obviously, it never happened. Maybe she didn't understand how hard or how costly that would be. But she never talked about representing herself, ever. She said, I don't want that attorney, I don't want that one, and I don't want that one. And we talk about hiring and firing attorneys, but let's not lose sight of, these are appointed attorneys. And when clients get mad at me, I often tell them, you didn't hire me, you can't fire me. I am on your case until I'm relieved by the court. So you can file a motion or I can file a motion, but you don't just fire me. That's not the terminology. And I think that there, as a matter of law, that there should have been some colloquy with Ms. Childress after the permanent custody motion was filed. And if the court was satisfied that Ms. Childress sufficiently understood and at that point waived her right to counsel, wanted to represent herself, then I think it's fair to say you chose to represent yourself. But when the magistrate, in the middle of this cross-examination, I'm going to say it was almost an argument, when the magistrate says you chose not to be represented, and Ms. Childress immediately says that's not true, how do we just move on with the questioning of witnesses there? There has to be, there should have been some colloquy before that. Now, the guardian ad litem indicated that there's been, and maybe it was the state too, that there's been a disengagement over the 2-year span of this case. My review of the record shows that Ms. Childress, the only times that she was not represented and not present were August 18, 2021 for a motion hearing, and on January 13, 2022 at a pretrial hearing preceding this permanent custody trial. Now, obviously, Ms. Childress, even though the dates were set at that pretrial hearing, obviously she got notice. She must get her mail or have some other way to keep in contact because she showed up, albeit late. She showed up. When she was late, the magistrate's concern was with where's the parents. She never once asked, where's Ms. Childress? Has anybody heard from her? I think when she showed up, she submitted to the authority of the court. And I think at the first opportunity, she indicated once again that she intended to have counsel. Now, let's not lose sight, she actually had 4 attorneys, because after she got the decision in this case, she managed to go get James Costin appointed for the objections to the magistrate's decision to be heard in front of Judge Powers. And so, once again, she always intended to be represented. If we get to a point where we talk about an abuse of discretion, I think it was an abuse of discretion at the point that it was suggested that the trial be continued in progress, such that Ms. Childress would have this one last chance on Mr. Williams' money to bring an attorney for her case in chief on some future day. To deny that request for that continuance, albeit it's an implicit request, we'll stand that that was an abuse of discretion.
It sounds like you would say it's an abuse of discretion because the trial court had articulated that she did not want an attorney, and that's different than what the record reflects.
That's true. That's true. She never said she didn't want an attorney. She never said she wanted to represent herself.
No, I'm saying exactly what I think that that she had chosen not to, whatever it was that the magistrate had said. I can't remember exactly the words.
Right.
but-
Whatever the magistrate said was not confirmed by Ms. Childress.
Well, more so that it wasn't reflective of the record.
That's true. It was not reflective of the record.
My only question, Mr. Kuchar, depending on what happens here today, do you promise to stay with this case until its ultimate resolution, whatever that might be?
And these
swear you in.
proceedings are
I can swear
taped,
you
just to
in,
let you
too.
know.
That's an interesting
Swear
question.
you in. You're the 5th attorney, right?
If you look back to the M. Children case, that's exactly what I did. I brought that case here, and then I stayed with it until the end next time, whatever happens, yes.
I'll give you a couple seconds to wrap up.
Respectfully, Your Honor, that's all we have. We're asking for a remand to the trial court to ensure that litigants in these positions are warned of the consequences and of their right to have an attorney after this most important motion is filed for permanent custody, to make sure that they clearly understand what's at stake. Thank you.
Thank you to everyone for all of your arguments and all of your efforts on this case. Very much appreciated. We will take the matter under submission, issue a timely decision. Wish you a wonderful afternoon, safe trip home, and hopefully no more snow for the week.
Thank you.
Thank you. That wraps up today. Oh, no. Well, we don't have hearings on Wednesdays.
I heard there's an accumulation.
Oh, my, yeah, I haven't checked. Oh, my, okay. Well, it is January.
Sorry to be the bearer of bad news.